Now, I became concerned that my taped lectures, online lectures are about an hour online, and then the students come for their workshops. I became concerned that the talking head with me droning on was not really, capturing students' fascination. And so I tried to intersperse the lecture with short videos, especially on topic areas where students were being very visual in their learning, have difficulty coming to grips with language-based concepts. And so I began by trialing some introductory scenarios on InVideo, an AI tool for generating videos. So if you go to the InVideo website, you'll see there's a place to put in a prompt. And the prompt that I entered was simply an introductory, no more than maximum of 3-minute video to demonstrate kind of scenarios where legal issues arise. And this was, in fact, shortly after the Francis Key Bridge in the Baltimore crash. And of course, I had to explain to students that.
I'll see those of you coming to Law Assessment Design in 10 minutes. For those of you who decided not to enjoy my hosting, you can go to the Practical Legal Learning one. Thanks all.
Thank you, William. Thank you.
Yes, thank you, everyone. Kia ora. Nice to meet you, Ursula and Benedict. Also.
Shall I show the video?
Yes, please.
Okie doke. So this is what I got. It's just over 2 minutes after popping in that prompt. And you can, in fact, edit the video. Can you hear?
Picture this. A colossal cargo ship packed to the brim with valuable goods sets sail from Australia, destined for Baltimore, USA. Everything seems to be going according to plan. But then, disaster strikes. As the ship approaches Baltimore, it collides with the Francis Scott Key Bridge. Containers topple into the churning waters below, and the goods inside are lost forever. The question on everyone's mind: who pays for the lost cargo? In the world of maritime shipping, liability is a complex web. The carrier, yes, the ship itself and its operators, usually have a limited liability. This means that in many cases, they aren't responsible for the full value of the lost goods. But why is that? Well, it comes down to a principle known as the Hague-Visby rules. These international rules set the liability of the carrier at about 666.67 SDRs per package or unit, or 2 SDRs per kilogram of gross weight of the goods lost or damaged. SDRs, or special drawing rights, are a type of currency used by the International Monetary Fund. Essentially, this limits the amount a ship operator has to pay out. However, there are exceptions. If the ship is found to be unseaworthy, or if the carrier is proven to have been negligent, they could face higher liabilities. For instance, if the collision with the bridge was due to poor maintenance or a navigational error, the carrier might be on the hook for much more. But what about the cargo owners? They often protect themselves through insurance. Cargo insurance can cover a wide range of risks, including the loss of goods in transit. In this scenario, the insurance company would step in to cover the loss, and then potentially seek reimbursement from the carrier if negligence is proven. So who pays for the lost cargo? It's a shared burden. It's a high-stakes game where the rules are designed to balance risk and responsibility.
Okay, so you can see that that was what I got, and I decided that was actually it's not too bad. It seemed to know what the limits of liability were in the Hague-Visby rules. It picked all that up just from that prompt. And so I wanted to test whether it could explain more sophisticated concepts that students often have trouble understanding. And one of the areas that one of the concepts that students often have particular difficulty with is not so much the idea that carriers have to have a seaworthy ship. They get that. No one wants to go on a ship or a plane if it's not fit to travel. And they don't have too much problem with the idea that carriers need to look after the goods properly and carefully. But they do have problem with this concept of the exemptions, the idea that a carrier is exempt from liability if damage is caused by act of God or perils of the sea. They can sort of get that if it's not my fault, it's not my fault, and I shouldn't be liable. But this concept here, the carrier not being liable if there is an act or default of the master mariner pilot in the navigation or management of the ship, the navigational error exemption from liability. They have trouble with that because surely if a carrier is normally liable for the neglect of the carrier's servants and agents, surely the master or pilot of the ship is very much an agent of the carrier, a servant of the carrier. And if they muck up, they muck up. And why should it matter if it's in the navigation or management of the ship? So they have trouble with that idea. And so I asked the InVideo to create a scenario. This is the prompt that I put in. Please create a scenario to illustrate the difference between loss of cargo caused by negligence in the navigation or management of the ship and loss of cargo caused by a failure to properly care for the goods, and explain why the carrier is not liable for the former, but is liable for the latter. And this is what I got.
All right, trade law students, let's dive into a fascinating scenario to help you understand the nuances of maritime liability. Imagine you're on a majestic cargo ship sailing across the Atlantic. The vessel is loaded with high-value electronics destined for eager consumers on the other side of the ocean. Now, picture two very different situations that could occur during this voyage. First, let's talk about navigational errors. Say the ship's captain, trying to save time, decides to take a shortcut through a notorious rocky area. Unfortunately, the ship hits an uncharted rock, causing it to veer and jostle, damaging some of the cargo. Here's the key point. Under maritime law, the carrier is generally not liable for damage resulting from negligence in the navigation or management of the ship. This principle stems from the understanding that navigation is inherently risky, and such errors are often considered part of the perils of the sea. So, even though the captain's decision led to the damage, the carrier can avoid liability because the mistake was navigational. Now let's switch gears to the second scenario, improper care of the cargo. Suppose the crew, in their haste to load up the ship, stacked the electronics improperly. They didn't secure the goods with the appropriate straps and padding. During the journey, the ship encounters rough seas, and the unsecured cargo shifts, gets jostled and sustains significant damage. Unlike navigational errors, this situation falls under the carrier's duty to properly and carefully care for the goods carried. Here, the carrier is liable for the damage because they failed to exercise due diligence in handling and securing the cargo. Let's recap. Navigation involves confronting the inherent risks and uncertainties inherent in any long and potentially dangerous journey, and that are somewhat outside the carrier's control. And so the rules were drafted so that carriers are not liable for loss or damage resulting from navigational error. On the other hand, by ensuring proper loading, securing, and monitoring of the goods, the carrier can prevent most damage that isn't caused by external factors. If the carrier's failure to fulfill this duty is the cause of loss or damage to cargo, the carrier is on the hook. Understanding this distinction is crucial to apportioning liability for the loss of the cargo. Thanks for watching, and see you in the next video.
And so you can see that that was actually a pretty good job because students can see that dramatic vision of a ship trying to navigate on violent oceans, and they can visualize the concept that navigation is one of the inherent perils that you will be exposed to whenever there is a journey by sea, and that really that is such an inherent peril of even going on the journey that it's not, the carrier should not be liable for any defaults that occur. So I actually thought that that was in many ways better than a talking head trying to explain all that without that visual background. So I just wanted to share that with you.